in September in coordinators meeting. And now we're moving to item 6, right? Yes. Which is presentation of the study of cross-border legal recognition of parenthood in the EU. And floor goes to the expert, who is Ms. Alina Trifanidou, Professor of European Law, Neapolis University, Paphos, from Cyprus, by remote connection. Please, Ms. Trifanidou, floor is yours for 10 minutes.
Okay, thank you very much. Actually, I was told initially I had 20 minutes, but I can make it shorter and then I can receive questions. Okay, so this study was obviously had as its aim to consider the proposal by the Commission regarding the cross-border recognition of parenthood. Next slide, please. So the aim of the study was, first of all, to explain what is the problem of non-recognition and its causes. Then the study includes a chapter where the current legal framework and the solutions that it provides to the problem of non-recognition of parenthood was analysed, and the gaps that remain despite these solutions were also pointed out. Then the study also includes a chapter where the Commission's proposal is analysed, the various provisions of the proposal and what they aim to achieve. Then there is a chapter on the providing a critical assessment of the proposal. So what the proposal is going to bring, what problems it will solve. It also explains what problems it will not solve. So also it speaks about the gaps in protection that will remain even if the proposal comes into force. And of course, it explains the main challenge that will be faced by the proposal, which is the requirement of unanimity in the Council that needs to be achieved in order for the proposal to become legally binding. And then, in the end, the study makes a number of recommendations for improvement of the proposal, but also more broadly in order to ensure that this problem of non-recognition of parenthood is, to the best possible, in the best possible way, resolved. Taking into account, of course, the competences of the EU with regard to issues concerning parenthood. Next slide, please. Okay, so when it comes to the regulation of parenthood, we need to have in mind that parenthood is a civil status that is central to a person's identity and from which many important legal rights and obligations are derived. So many rights which a child derives are dependent on proving that that child is the child-in-law of one parent or both parents. So it is a very important status from the point of view of a child because its proof leads to rights and entitlements for the child and, of course, by extension, for the parents. Each member state has developed its own concept of civil status, taking into account its history, culture, and legal system. So in the EU, we have currently 27 different laws regarding how parenthood can be established in each different EU member state. This is due to the fact that substantive family law is an area that falls within member state competence. This is how things are, and this is not going to change as a result of the proposal under examination in this study. So substantive family law, and in particular the question of how parenthood can be established in a member state, is a matter that falls and will continue to fall within member state competence. However, when it comes to private international rules, at the moment, each member state maintains its own private international rules regarding parenthood. and in particular with regard to the establishment of parenthood in cross-border situations, as well as with regard to the recognition of parenthood established abroad. Now, private international rules, I don't have much time, but I'm going to explain briefly here. Private international rules are the rules that determine which law is applicable or which court has jurisdiction in a case where a situation has points of contact with more than one legal system. For instance, if we have a child that is born in member state A and the child is born by parents who are nationals of member state B, then member state A may say that the determination of the establishment of parenthood lies with the laws, the parenthood laws of the state of birth of a child. Whereas member state B, under its laws, under its private international law rules, may state that the establishment of parenthood of a child depends on the laws, is regulated by the laws of the member state of nationality of the parents of a child. So this distinction, this differentiation in the private international law rules of the member states means that we may have different results with regard to the question, different answers to the question of which law is applicable in a situation, in a cross-border situation, which has points of contact with more than one member state. So the proposal under examination in this study, the parenthood proposal, has as its aim to harmonize the rules of the member states, the private international rules of the member states with regard to parenthood. So what the proposal will do will not be to change the substantive family laws of the member states with regard to parenthood, but rather to provide common private international rules for all member states with regard to which court has jurisdiction to determine the establishment of parenthood of a child in a cross-border situation, which law is applicable in such a cross-border situation, and of course to require the immediate recognition of parenthood established in another member state without leaving any choice to the member states with regard exactly to this question of whether they will recognize parenthood established in another member state. Next slide, please. Okay, so what is the problem of non-recognition? The problem of non-recognition, which currently exists, and I'm going to oversimplify here, is that a family which is legally considered a family in one member state, let's say member state A, where the filiation between the child and both parents has been legally established, may be faced with a situation where in a number of other member states the parenthood of the child, and in particular the parent-child relationship between the child and one or both parents, will not be recognized in those other member states. So this will mean that in the eyes of the law in those member states where recognition is refused, the child will be a stranger to the parents that have been established as the child parents in member state A. This is obviously problematic because this means that the parent that is not considered legally a parent of the child in the other member state or member state will no longer be able to represent the child as a parent, to register the child at school, to open a bank account for the child, to travel with the child, etc., etc. Now, this problem of non-recognition of parenthood in the EU is caused by the combination of the existence of different substantive rules in member states regarding the establishment of parenthood, together with the existence of different private international law rules in member states with regard to the establishment of parenthood in cross-border situations and with regard to the recognition of parenthood. As I have already said, the EU does not have competence with regard to substantive family law, and this does not change and will not change unless, of course, in the future there is a treaty amendment. So the proposal under examination does not affect the substantive laws of the member states. So even if the proposal becomes legally binding, the member state will continue to be able to decide how parenthood should be established in their territory, what are the procedures that must be followed, who can become a parent, in what ways someone can become a parent, etc., etc. However, what the proposal under examination will do will be to harmonise the private international law rules of the member states with regard to the establishment and recognition of parenthood in cross-border situations. Next slide, please. Okay, now, at the moment, some solutions to the problem of non-recognition of parenthood have been offered by EU law and by the European Convention on Human Rights as it has been interpreted by the European Court of Human Rights. So we are all aware of the VMA case, the so-called Baby Sarah case, which established, the European Court of Justice established in this case that when a child has been recognized as the child of two parents of the same sex in one member state, on the facts of the case that was Spain, the child will be able to require another member state to recognize those parents as the child's parents within its territory for the purposes of ensuring that the child as a union citizen and or the parents as union citizens can exercise their rights deriving from EU law, and in particular for exercising their EU free movement rights and any rights associated to those free movement rights. So, in other words, the VMA case established that once parenthood has been established in one EU member state, it should be recognized in every other member state, and I underline here, for the purpose of exercising EU free movement rights. So, VMA provided a partial solution to the problem of non-recognition of parenthood, meaning parenthood must be recognized everywhere in the EU for the purposes of the exercise of EU free movement rights. But this does not require cross-border recognition of parenthood for other legal purposes. For example, once the family is in the territory of another member state, the VMA case doesn't require recognition of parenthood established in another member state for purposes such as maintenance, succession, the consent given by the parents for medical treatment for the child, and any other purposes. Now, when it comes to the European Convention on Human Rights, we are all aware that every EU member state is a signatory state to the European Convention on Human Rights. We are also aware that Article 52 of the Charter provides that the provisions of the Charter must be recognized as giving at least the same provision as at least the same protection as the protection provided by the European Convention on Human Rights for the same right. So, although the European Convention on Human Rights is not part of EU law, nonetheless, the solutions offered by it are binding on EU member states, not as a matter of EU law, but because they are signatory states to the European Convention on Human Rights, but also the protection and the solutions offered by the European Convention on Human Rights must be considered as solutions that are offered also by the Charter as a result of the requirement laid down in Article 52 of the EU Charter of Fundamental Rights. Now, very briefly, the European Court of Human Rights established that in situations where we have an adoption order by a court of a third state, on the facts of the case there was an adoption order by a Peruvian court, So this established parenthood in Peru of a child by her adoptive parent, this adoption order should be recognized by all signatory states of the of the European Convention on Human Rights. This was considered to be required by Article 8 of the European Convention on Human Rights, which is the right to private and family life. Then, in the Menesson case and the European and the advisory opinion of 2019, but also through a long list of other cases which we don't have the time to mention here, the European Court of Human Rights established that in situations where we have a surrogate-born child whose parenthood by the intended parent has been validly established under the law of a country, the European Convention on Human Rights, and in particular the right to private life of the children, requires that the parent-child relationship between the surrogate-born child and the intended parent who is biologically related to the child must be recognized in the state of residence of the family. In the advisory opinion delivered in 2019 by the European Court of Human Rights, it was also clarified that in situations where we have the establishment of parenthood of a surrogate-born child by the intended parent who is married to the intended parent who is biologically related to the child, should also be recognized. And in particular, the state of residence of the family must ensure that it makes provision for a procedure through which the parent-child relationship between the surrogate-born child and the intended parent who is not biologically related to that child should be able to be established, for example, through an adoption order. In DB and others, these requirements were extended also to families who had children through surrogacy and where the parents were two persons of the same sex. So in other words, the European Convention on Human Rights has been interpreted by the European Court of Human Rights as requiring the cross-border recognition of parenthood validly established in a country, and this has been required in cases involving adoption orders and in cases involving surrogate-born children. Okay. Next slide, please. Now, what I would like to emphasize here is that in the EU context, there has been a long list of private international law instruments where the private international law rules of the EU member states have been harmonized in the family law field. For example, we have with regard to succession, with regard to maintenance. However, to date, there hasn't been any legislation at EU level which harmonizes the private international law rules of the member states with regard to parenthood. So the proposal under examination, which was published by the Commission last December, aims exactly to do this. So the proposal under examination does not harmonize the substantive family laws of the member states with regard to parenthood. So it doesn't tell the member states that you have to allow, for example, surrogacy in your territory, or you have to allow two parents of the same sex to become parents in your territory. The proposal doesn't do that. What the proposal does is simply to harmonize the private international law rules of the member states with regard to parenthood. So, in particular, this proposal adopts common rules for the determination of the courts of the member states that have jurisdiction in matters relating to the establishment of parenthood in cross-border situations. In other words, in situations where we have points of contact with more than one member state, and in other words, we're not sure which court of which member state can determine whether the parenthood of a child should be established, then this proposal aims exactly to provide the rules which determine which one is the court of which member state that will have jurisdiction to deal with this issue. Also, this proposal adopts common rules for the determination of the law applicable to the establishment of parenthood in cross-border situations. Again, in situations where we have points of contact with more than one member state and involve the establishment of parenthood of a child, so we are not sure whether it's the law of member state A or member state B that is applicable to determine who is or are the parents of a child. This proposal aims exactly to determine which law, the law of which member state, should be applicable. Then this proposal imposes a mutual recognition obligation of parenthood established in a member state. So if this proposal Another point that, another gap, let's say, or another challenge that will be faced when this instrument will be applied is the public policy exception. A public policy exception is always included in private international instruments, so I'm not criticizing this instrument for including such an exception. It goes without saying that it would include it, but it needs to be borne in mind that such an exception may be abused by some member states in order to try to avoid their applications under the instrument. So caution will need to be exercised when the instrument will be applied in order to ensure that this exception is used appropriately. However, the most important challenge will be exactly to ensure that unanimity in the Council is ensured, because if it's not, is secured, because if this is not achieved, then the proposal will just be, will simply not come into force. Next slide, please. So the study, based on these gaps identified and the challenges that have been identified as well, the study has made a number of recommendations. The first recommendation has to do with the fact that this proposal is a very technical instrument, so it's very difficult for anyone apart from private international lawyers to really know what it requires and how it should be applied. So this means that it would be very important for the Commission to issue guidelines on the proposed regulations application and enforcement. And at the same time, it will be important for anyone involved in the enforcement and application of the proposed instrument, such as national judges, civil servants, and legal inclusive and respects the fundamental rights of all children, and obviously it needs to respect fundamental human rights as these are laid down in EU law. It is important, obviously, to include within the scope of application of this instrument and within the protection it offers every single child. So it is recommended that surrogate-born children, as every other child, should stay within the scope of application of this instrument and should be protected by this instrument. Then, with regard to Denmark and its opt-out, obviously nothing can be done, but it is recommended that the Commission and the Member States need to work together in order to persuade Ireland to opt in order to ensure that the instrument, if it becomes legally binding, will apply at least to the 26 out of 27 EU Member States. Next slide, please. Then the other recommendation is with regard to the right of the child to know its origins. As I said before, this can be considered to be implied as a result of the fact that the regulation obviously needs to be read in line with the fundamental human rights protected under EU law. But in my personal view, it would be much better if there was one provision which explicitly notes that the regulation should be read in a way which ensures that the right of the child to know its origins should, as far as possible, be protected. Also, once and if the proposal becomes legally binding, it will be very important for the Commission to ensure that the public policy exception laid down in this instrument is interpreted restrictively, and that the member states are allowed to rely on it exceptionally and only when there is a genuine danger to their public policy. In other words, the safeguards that have been applied with regard to the application of the public policy exception in other areas of EU law, such as in free movement law, should also be applied in the context and I feel version of the original proposal, but this will be problematic in that the most controversial aspects of the proposal are those which where recognition is mostly needed, and so if we end up with
que nous ne savons jamais si l'unanimité peut être obtenue. and ideally it will take the form of the proposal as it currently is, because at the moment it goes probably taking into account the competences of the EU
what you already mentioned several times, that these issues fall under subsidiarity, so we can basically do nothing. I don't want to sound very pessimistic, just a question. Another question is, I just wanted to have an example. I'm coming from Estonia, and we recently legalized same-sex marriage. So let's pretend that we have same-sex couple with a child who is moving to Poland, where they obviously are not big fans of same-sex marriages. And what is practical solution given by this proposal for this particular family? How do you see it practically? For, as you mentioned, the idea is that a commission have to determine which court is in charge of, and here comes another issue. You mentioned that there are which can be definitely considered to be public policy. So do we really have the solution here? Or this is kind of good intention, which is maybe not applicable, even if tomorrow we will have unanimity in the Council? I'm sorry for being so skeptical, but these are the questions which I've got in these 33 minutes of your speech. Maybe Mrs. Auken also wanted to ask, and then you will, yes.
All over the EU. This law is there. All over Europe. And I would say, for Denmark, we were the first country in the world to legalize same-sex partnership, and we very fastly after accepted stepchild adoption, and this problem on or what you would call it, was solved within already now Danish laws. I cannot see that Denmark can be a problem, even if we have the opt-out on the legal thing, just to say this here. But just want to ask you, why is, I think you said it different, but altruistic surrogacy is legal, but nevertheless, I think we should not make this here, the proposal here, more complex than it should be, and the right, of free movement and the right of the child, and we also have international law.
Благодаря, уважаема госпожо председател.
It's only in the room. Oh, nice.
Okay. Да превеждат нашите преводачи.
Can you hear us now in the English booth?
So let's, now I hear myself very well. Now something happened.
4, 5, 6, 7, 8, 9, 10, 1, 2, 3.
Can you hear us now? Can you hear us? So, Madam Chair, I'd like to thank the experts for this information, but I disagree with the way certain policies are hiding behind these proposals. Let me remind you, the European Union comprises member states with their
This is sabotage. A sabotage against sovereign ideas, sovereignist ideas. 7, 8, 9, 10, 15, 25, 30, 40, 12.
Can you hear us now? Can you hear us now? Obviously, the problem is when the speaker starts speaking and then interpretation stops, although we are working. So I'd like to express my disagreement with the way certain ideologies hide behind similar proposals. Member states are sovereign states and they comprise the European Union. In the first place, I should say that the draft regulation or proposal for a regulation in this case focuses in particular on the following. Single-sex marriages should not
It's back.
Okay. Искам да напомня, че...
So let me also say that in the initial proposal, in this case, pays particular attention to not exerting any impact on legalizing single-sex marriages. However, when we read the text of this proposal, we see that the text seems to imply this legalization. It seems to me that certain political ideas, like the idea in favor of legalizing single-sex marriages, is to be found in this document. The European Commission has decided that in this case we should have a European regulation. Yet again, member states are incapable of taking their own decisions in the area of family law. I'm asking myself another question. Why is it that nobody is revising Regulation 216? I was a rapporteur on this regulation, and the aim of this regulation was to simplify requirements for presenting official documents in the European Union. As a result, in the case of certain official documents that are issued in one member state but have to be recognized in another member state, so all these procedures are simplified. We can do the same thing here. For instance, the birth certificate, it's a clear document. You can see who the parents are. They're written in the birth certificate, and it will be recognized. We also have the court case in Bulgaria, C419. We have called on the European Commission to take action as to what Bulgaria has done in view of its compliance with European Union legislation. This decision should be taken not lightly, because we should think of the Constitution of the Republic of Bulgaria and its Article 46. Article 46 of the Bulgarian Constitution defines marriage as the union between a man and a woman. That's why we do not recognize adoption of children by single-sex parents. In this case, one should simply interpret the Constitution of the Republic of Bulgaria. The father needs to be a man, the mother needs to be a woman, and no pressure should be exerted to adopt controversial legislative norms. Sovereign member states should not actually be forced to violate their own law and to forget about their own national identity. Actually, we expect that these regulations should give more rights to European citizens, should make their life easier in the case of transborder relations. But this aim should not be used as a loophole, as a way of enforcing policies and ideas that have nothing to do with the laws of the Republic of Bulgaria. This can be easily checked, and that's why I disagree with it. Thank you.
Thank you very much. Now I understand we have also Commission here, so I suggest that maybe expert will keep in mind our questions and will reflect on them later, but now we give the floor to the Commission, and we have here Maria Villar-Badia. I'm sorry if I mispronounce your name. Please, floor is yours for 10 minutes or less. But as experts spoke for half an hour, maybe you have something to reflect on that. Thank you.
Thank you very much, Madam Chair, and good afternoon, everyone. Thank you for inviting the Commission to present the proposal. In fact, Professor Trifonidou and myself keep meeting in every Parliament meeting on the proposal, so just as a starting point, I must say that we agree on the main lines as to what happens today and as to what the purposes of the proposal are. And I know that Professor Tifonidou has some criticisms of the proposal, which are, of course, any comment is welcome by everyone. As you know, currently the proposal is being discussed with the Member States and Council, and of course also within the jury committees, the FEM committees and the LIBE committees, and I see that now also here in the Peti Committee. So we are very happy that the proposal is being discussed as much. Probably I don't know, because as I missed the presentation by Professor Tifonidou, I may say things that she has already said, but for us, for the Commission, it is important that we are all aware that there are several difficulties currently that families encounter when they want to have the parenthood of their child recognized in another member state. And for the last many years, actually, citizens have been bringing to our attention these difficulties. They've been bringing to the Peti Committee also these difficulties, and we've seen that there have been several cases at national level, some of which have reached the Court of Justice. So the Commission thought that it was time to do something about this. And why is that? Well, as I'm sure Professor Tifonidou has explained, today already union law requires member states to recognize the parenthood of a child for the purposes of rights under union law. And the rights under union law are essentially the rights under the current EU law on free movement. So essentially the right to enter another member state, for example, during traveling, during holidays, also the right to establish residence in another member state, the right to obtain travel documentation for a child, like a passport. And the court made very clear in the recent VMA case, also known as the Baby Sarah case, that this obligation that currently exists on member states to recognize the parenthood of children also applies to children with same-sex parents. The court made very clear that it is the fact of having to recognize the parenthood of a child with same-sex parents for the purposes of rights under union law, and that I'm trying to respond to some comments that have been made, does not affect the national identity of member states and does not affect the public policy of member states. So the court has been very clear in this respect as regards rights under union law. Now, because the difficulties with the lack of recognition of parenthood do not affect only the rights under union law, but also the rights under national law, and those are rights such as succession, maintenance, the right of the two parents to legally represent their child in another member state on matters such as schooling, education, or even the management of property, then the Commission President said in her State of the Union speech in 2020 that if you are a parent in one country, you're a parent in every country. And the Commission adopted in December last year a proposal aimed to simplify the recognition of parenthood between member states. And this is the proposal that you've been discussing today. I would like to stress that this proposal, of course, would apply as a complementary of the current union law on the recognition of parenthood for the purposes of rights under union law. It is a proposal that would cover all purposes, so the recognition of parenthood for all purposes, whether for rights under union law or for rights under national law. But I want to stress that this proposal will not affect in any way the national law of the member states. Under the treaties, as you all know, the competence on family law, substantive family law, is within the member states. So it falls to the member states to define family, to decide whether or not they allow same-sex marriage in their territory or parenthood by same-sex parents in their territory. However, this proposal is not about that. This proposal is about facilitating the free movement of families, and obviously the free movement of families, it is seriously affected if people...
I'm sorry, colleagues, I mean, it's impossible to listen, really. What a chatting chamber. I'm sorry, please continue.
Yeah, so because the families are encountering all these difficulties in having the parenthood of the children recognized, families, in particular, it is a fact, same-sex families, they are deterred from exercising the right to free movement. And obviously, the right to free movement is one of the cornerstones of the Union, and that's why it is essential that parenthood be recognized between member states. And I stress between member states because member states will continue to be able to apply their national law to the recognition of parenthood when the parenthood has been established in a third country. So obviously the member states among themselves should have a closer relationship than the relationship that each of them has, whether with the US, Japan, Kazakhstan, India, or Morocco. It doesn't matter. So between the member states, obviously this recognition of parenthood, which is a civil status, should be facilitated. And this is the purpose of this proposal, because in the end, this is all about strengthening the protection of the rights of children, protecting the best interests of children, which we fully realize that this is interpreted differently in each member state, but the concept of the best interests of the child is a concept that it is enshrined in international law, in particular in the UN Convention of the Rights of the Child. So it is a very clear concept in all international law, which the member states have introduced in their national law, because they are party to all these international conventions from the UN and from the European Convention on Human Rights. So with this view, with a view to strengthening the protection of the rights of children in cross-border situations, that's why the Commission considered that this proposal should be adopted. And I insist that this proposal only affects cross-border situations. It does not affect situations where everything is national. So if there are two parents which are of the same nationality of the member state in which they live, and they have a child in that member state, all this is national. So in these cases, the proposal would not apply. The proposal would only apply to situations where there is a cross-border or otherwise called international element. So for example, one of the parents is of a different nationality from the member state in which they live, or the child is born in a state which is not the state of the habitual residence of the child or of the parents, basically this. So in these situations where there is an international element, the Commission is proposing to harmonize the rules that the member states currently apply. So currently each member state applies its own rules, deciding which courts are competent to issue judgments in cross-border situations on parenthood. Each member state decides which national law should apply to establish the parenthood of a child in a cross-border situation, and each member state decides how to recognize judgments and documents on parenthood issued in another member state. Because of these different rules of each member state applicable in cross-border situations, it happens that a member state that considers under the law that it chooses to apply that a child has as parents A and B, when there is a cross-border situation, so for example, where the parent and the child move to another member state, then this parenthood is not recognized, and suddenly the child actually has different parents, has either a different father because of different rules on the legal presumption as to who the father of a child is, or they lose a non-genetic parent because they don't allow same-sex parents to have both of them children in the member state. So this means that in different member states, one same person can have different parents, which is rather unacceptable, we think. So because of this, the Commission is proposing to harmonize these rules on which court is competent to issue judgments on parenthood in a cross-border situation, which national law should apply to decide the parenthood of a child in a cross-border situation, and to simplify the procedures for recognition of both judgments and public documents on parenthood issued in another member state. I repeat that if the judgment or a document on parenthood have been issued in a third country, then the member states will continue to apply their own rules. As to the scope of the proposal, obviously we have to comply with the Charter of Fundamental Rights. So the scope of the proposal is very broad. It basically does not discriminate among children depending on how they've been conceived, on how they've been born, or on their type of family. So it applies to all children, which means that the member states where the parenthood of a child has been established in accordance with the rules in the proposal, all other member states will need to recognize that parenthood. And that means, indeed, that if a member state allows parenthood by same-sex parents under the law designated as applicable by the proposal, if that law allows parenthood by same-sex parents, then all other member states will need to accept that. They will need to recognize that. At the same time, the proposal ensures that rights that today are for the benefit of same-sex couples because each member state does their own thing. So that means that same-sex couples can try to have the parenthood of their child established in a member state which is friendly to their situation. So we didn't want with this proposal, by harmonizing the rules, to remove rights that already exist for same-sex couples. So this means that if in a member state the parenthood is established as regards only one parent, because under the law applicable as designated by the proposal, the parenthood by same-sex parents is not allowed. So let's assume that in a member state parenthood is established as regards only one parent, the genetic parent, but not as regards the other parent, the spouse, the same-sex spouse. That does not prevent the other parent to go to the member state of their nationality or the member state of the nationality of their spouse and have the parenthood established also as regards the non-genetic parent. So this proposal does that, aims to make sure that fundamental rights as already exist today under the current situation we will not backtrack on those, and at the same time facilitating the recognition of the parenthood. And in addition to harmonizing the rules on jurisdiction, applicable law and recognition, we are proposing the introduction of a so-called European Certificate of Parenthood, which is a document that will be issued by the national authorities, but in accordance with the procedure laid down in the proposal, and which can, it's not compulsory, but can be used by families if they want to, and if they ask for it, the member states will need to issue it, which is just a document that proves parenthood as established in a member state. It proves it in another member state. And so this ECP, as we call it will exist in all languages because it will be in an annex to the proposal. It is in an annex to the proposal. It is gender neutral, so it doesn't talk about mother and father, it talks about parents, because obviously all the legislation of the Union on family law is gender neutral. So this is also, we think, a document that will facilitate the recognition of parenthood. So the issue of surrogacy has been mentioned. The issue of same-sex parents has been mentioned. The issue of nationality is typically mentioned in these debates in Parliament. I want to stress that this proposal is not about surrogacy. Each member state will continue to be able to decide whether or not they allow surrogacy in their territory. Each member state will continue to be able to decide whether or not they allow parenthood by same-sex parents in their territory. The same with assisted reproductive technology, but this does not mean that when a member state has established parenthood in accordance with the proposal as regards a child that has been born out of surrogacy, not in a third country, but in a member state, or a child has been born out in a family that has where the parents are same-sex, this doesn't mean that the other member states will not be required to recognize that parenthood. So within their territory, each member state will continue to do whatever they want, but they will have to recognize what other member states do, and that is because under the treaties, each member state continues to keep its competence on substantive family law, but the treaties, as you all know very well, under Article 81, allow the Union, well, confer to the Union the competence to propose and adopt rules on family law with cross-border implications. And that typically is, as I mentioned, harmonization of rules and jurisdiction, applicable law recognition. So this has to be clear. This is not about surrogacy. We have seen that surrogacy is often used as a very serious problem to attack the proposal. But it should be made clear that no member state will be obliged by the proposal to all of a sudden have to allow surrogacy. But once a child has parents in one member state, the child should be able to continue to have the same parents in another member state, because otherwise there's no continuity of identity, there's no continuity of parenthood, there's no legal certainty, there's no free movement of families as we think it should be. And as I said, the fundamental rights and the national law are affected. Let me just, to finalize, give a very typical example. A child that has two same-sex parents, so one is genetic, the other is just a spouse, and this couple has a house in another member state. The non-genetic parent is the owner of the house in another member state, and he or she dies. But then in the other member state where the house is located, they don't recognize the parenthood of this child as having these two parents established in another member state, so they don't allow the child to inherit the house of the non-genetic parent, who was the spouse of the same-sex genetic parent. That is unacceptable. So losing rights to succession, losing rights to maintenance in case of divorce, losing rights to legal representation cannot be accepted within the Union. So this was just an example. So I'll stop here. Of course, I'll be happy to reply to any questions. Thank you.
Thank you. Thank you very much. It was really very interesting. Colleagues, if you stop running in the room, it will be much easier to listen to the experts. I'm sorry, really. I'm sorry, you know. Yes, I don't know, maybe I'm the only one who have questions in the room, but I will ask them. You mentioned same-sex parents, one of them genetic and another not. Does it also, your proposal, solve the problem of same-sex couples who adopted the child? And my other question is, I'm sorry, I'm not very well aware about the proposal. We discussed it for an hour now, but still, you know, the less you know, the less questions you have. Now I'm starting to have questions finally. You're speaking, I understand that Commission was very inventive making this proposal, I mean, due to the limitations we have. You are speaking constantly, and also our experts spoke about free movement. So do I understand correctly that if this couple in question, so to say, these parents in question move to another member state who is not so friendly to them, or whatever they are, so they can move there, they can work there, their parents there, but what about parent leave, what about social money, whatever, you know, all these things under subsidiarity do not apply to them. Do I understand it correctly? Thank you.
Thank you very much for these two very pertinent questions. Let me start by the second one. So today, it is a difficult issue. We all realize that. So today, member states already are required to recognize the parenthood of a child, regardless of whether the parents are same-sex or different sex. And this obligation stems from union law that already exists on free movement, and on, in particular, as confirmed by the Court of Justice in this VMA or Baby Sarah case. So this means that if two same-sex parents, go on holidays to another member state, and let's say that the child is traveling with the non-genetic parent, whose parenthood has been established, let's say, in a member state where they accept parenthood by same-sex parents. It is possible that because this person is traveling along with a child, it can be that authorities stop the person, not because of any reason other than, as you know, there's lots of problems of children abduction, and sometimes the authorities stop and they check whether at least the parenthood exists, and sometimes they also check whether there are custody rights. But let's stick to parenthood. If that situation arises, the parent who is traveling with the child, although they are not the genetic parent, if they are a parent as established in another member state, that person is allowed to prove the parenthood with any kind of document, and the member states are required already to allow that parent or the two or the couple, the same-sex couple, if they're traveling all together, to enter another member state and not making any trouble. The same if they want to move to another member state. And that is already the case as under union law and under case law. So that has to be clear. But as you very well said, okay, the rights and the free movement are limited. It's basically to summarize, the right to enter, as in the situation of holidays, the right to take up residence, which means that if you go to the commune, it should be sufficient for the parents to choose to show any document. The court does not really demand, and union law does not demand any specific document, so any document that they have proving the parenthood, and so to establish residence. Now, but this couple wants to stay in that member state and wants to live there. Issues such as family allowances, tax cuts, the right to decide whether a difficult operation can take place, the right to decide whether the child can go on a 2-week trip while being a minor. All these issues are not covered by free movement law. So that is why we are proposing this proposal, because this proposal would cover both the rights and the free movement law, but also, and in particular, the rights and the national law. And the rights and the national law are all these rights: tax cuts, family allowances, succession, maintenance, legal representation for medical reasons, legal representation for schooling reasons. It is why it is so necessary, because same-sex couples or other couples may be concerned that if they move to another member state to live, the parenthood of the children will not be recognized, and therefore they will not be able to benefit from the same rights as any other family in that member state. So that's why this proposal intends to cover this gap that exists in current union law. Then as to adoption. Adoption, how to adopt, the requirements, the procedures, all that is substantive family law. So it falls within the competence of each member state to decide how they will govern domestic adoption. Now, what is domestic adoption? Domestic adoption will be defined, is already mentioned in a recital, but we will probably define it also in an article, is an adoption where the child and the adoptive parents, the prospective adoptive parents, have the habitual residence in the same state, in the same member state, whereas international or inter-country adoption is an adoption where the child and the prospective adoptive parents have the habitual residence in different member states. So, for example, if my partner and I, same-sex or different sex, for example, in Belgium, where same-sex parenthood is allowed, if my parent and I want to adopt a child and the child, regardless of the nationality, has the habitual residence in Belgium, whether the two of us can adopt and what conditions we need to fulfill and whatever else, all this is governed by national law, Belgian law. However, it can be that our child, our adoptive child, later on, he wants to go and study in another member state, and then he needs to show a birth certificate. At that moment in time, there is already a cross-border situation. So in order to govern the adoption, Belgian law will apply. But once there is a cross-border situation, then the regulation applies, which means that the recognition of the adopted child will be done under the regulation. Now, what we're saying in the proposal is, if the child is adopted in any member state, the child will be adopted under the national law of each member state. But when the child needs to travel, if they need to show a document proving parenthood, then they will fall under the proposal. Of course, if the child is only traveling for holidays or just for the purposes of rights and the union law, they will not need to show the documents in this regulation. It will suffice to show any other kind of instrument. Why am I saying this? I'm saying this because it needs to be clear to the member states that if a family, same-sex couples, for example, are traveling with their child throughout Europe, and they want to see whether they are the legal parents, they cannot ask for the purposes of traveling. So one of the rights and the union law, so one of the free movement rights, the member state cannot require the family to show one of the documents in the proposal. They have to accept any document that the family wants to show. Why is that? Because it is only for the purposes of union rights, for the purposes of free movement law, where, as the court has made clear, any document is enough. If the family wants to establish themselves in another member state and want to benefit from all the rights under national law, tax, allowances, succession, etc., representation, then they will have to show one of the documents under the proposal. But going back to your question, which was on adoption, member states will continue to govern adoption. Member states will also continue to govern inter-country adoption, and there I should mention that there is a convention of on an international organization which is called the Hague Conference on Private International Law, which has its seat in The Hague, obviously, and which has a convention of 1993 to which all member states are party, and which govern the conditions and the requirements for inter-country adoption. So the member states have joined this convention, and if they comply with all these requirements under this convention, then among each other, they need to recognize the inter-country adoption. So because this is covered, the proposal doesn't cover this. The proposal covers domestic adoption, covers the recognition of domestic adoption. So a child adopted in Belgium that needs to prove his or her parenthood in Estonia, for example. But so we need to distinguish between domestic adoption and inter-country adoption. Inter-country adoption is covered by international law. Domestic adoption would be covered by the proposal. Thank you.
Thank you very much. It turned out that it's good that we have so few people in the room. We had time for very detailed answers. Mr. Angel, you wanted the floor, please.
Yes, thank you very much. First of all, please apologies that I came late. On the program, it said expressly underlined that this would start at 4:30, but I know that there was not enough people here, but I'm happy that this meeting is recorded so I can follow the excellent expert from Cyprus and also follow again the discussion from the comments of the representative of the Commission. For me, for SND, this is of course a very important proposal, and it puts the interest of the child at the core. This is important. We have to see it always through the glasses of the children's right. This is very, very important. And I just have one question, and also I want to thank the Petition Committee that we always discussed on this. We had a study commission for this, and you remember in this study, and we had this debate here on the legal basis. The legal basis where all the court rulings are based on the law on free movement on Article 21(1) of the treaty, but now this legislation has a different legal basis. And it seems that this discussion is close, which I regret. I think it would have been nice if we could have also had a debate with the Council in the trilogues later on, but as it looks in the committees responsible, they are okay with this legal basis, which is the problem is it will be very nice if we have a new legal document and all this in place, but it needs unanimity at the end if we keep this legal basis. And that's what I'm worried about, because I know other proposals which have been agreed by the Parliament, and then they are blocked because of the question of unanimity. So why did the Commission really stick on this other legal basis which uses unanimity and not try to find a little sideway through the free movement legislation, Article 21(1)? Wasn't it possible, or what was the problem? I still don't understand it. Why? Because we work on this very hard. We give expectations to many parents and also many children who have never seen their grandparents, mothers who have to go to other countries to die, because if they die in their country, the children will be taken away in the family. We know all these cases. We have had them here in different hearings. So we give false expectations to these families. We think we're working on something, and then at the end, it will be blocked again. So that's a bit my big problem with this whole legislation. And once again, I would have gone more detailed questions if I had listened to the whole debate, but I will follow it then online again. Thank you very much.
Thank you. Mrs. Alkan, please.
I totally agree with you, Mark. But I can say what I don't understand either is that you have the Hague Convention, you have the Human Rights Convention, you have the right of the child. I know that it's not all member states who has implemented this, but as far as I know, everybody has signed into it. So there should be legal, international legal basis for making this here work, because still the child, I can just tell some of those who call on Christianity to neglect the child. I'm a pastor. I'm a Lutheran pastor. I've been it for 43 years. And I will tell you, the weakest part is always what it is about. And it's not about having some stiff rules. It's about taking care here on the weakest part, which is the child. That is in the clear in the New Testament. It's clear in Christianity, and I get furious when I hear people using that kind of argument to stop basic humanity and Christianity like this. Just to say this.
So thank you very much. I don't know if Commission, you would like to reflect on what was said, and then we give the floor to the expert, please.
Yeah, thank you. Thank you, Chair, and thank you for the questions. The Parliament has been asking us this question at every possible meeting we've had, but of course we are happy to explain this because we understand that it puzzles. As you all know, and I'm sorry that I state the obvious, but as you all know, the Union has the competence that it has. It has the competence that have been conferred on it by the treaties, and no more than that. And as the treaties are currently today, and based on what the Court of Justice ruled in the VMA and Baby Sarah case, the situation is what it is, which means that the legal basis of Article 21, which of course the Commission also considered, because as you can imagine, the Commission would very much like this to be adopted. And so we are fully aware that it is easier to obtain a qualified majority and to co-legislate with the Parliament on this, specifically on this kind of causes, than having a requirement for unanimity without the Parliament having a co-decision position. So we very, very thoroughly and carefully examined what legal basis we could use, not only from a policy perspective, but in particular from a legal perspective, because we can only do what we can do. And, well, first of all, there is one specific article on family law in the treaties, which is Article 81, which, as you all know, is the one that requires unanimity and in Council, and the special legislative procedure, which does not involve the Parliament as co-legislator. This article is a special rule, what lawyers call lex specialis, so it's a special rule as compared with the Article 21 of the treaties also, which is a more general rule, which is the law on free movement. This is one legal argument that the legal service put forward. But what really was definitive, in addition to this already legal argument, is that the court made it clear that under Article 21, which is the article on free movement, which allows for the ordinary legislative procedure, member states are only required to recognize parenthood for the purposes of rights and the union law. The court did not say that the member states are required to recognize parenthood also for the purposes of rights and the national law. And it did that because the court obviously knows the limitations of the treaties as regards family law issues, and it just stopped there. The court made it clear that member states cannot invoke public policy or national identity to refuse recognition of parenthood for the purposes of rights under union law. So the court actually went very far and said, sorry, in Bulgaria, you cannot, in the VMA case, you cannot invoke national identity or public policy just because you have to recognize the parenthood of a child that has same-sex parents as established in Spain. And you cannot do that because recognizing that parenthood doesn't go against your national identity and doesn't go against your public policy. So it was very clear and very brave. However, it said for the purposes of rights under union law. It didn't say, and also for the purposes of rights under national law. So Article 21 on free movement has been very useful for the court to rule on the recognition of name, on the recognition of parenthood also, for the purposes of rights under union law. But the court has never said to member states, you have to harmonize your rules so that you have to recognize parenthood or name also for the purposes of rights under national law. The court did not ask that from the member states. The legislator has to do it. And the legislator is doing what it can do, which is a proposal on family law with cross-border implications only. As you know, the Union does not have the competence to say to member states, okay, from now on, you will establish parenthood like this, and like that, and you will establish name like this, and like this, and like that. No, it can only say either on the basis of free movement, as the court has done, and the name, or on the basis of harmonization of certain rules for cross-border situations, you have to recognize parenthood, also for rights under national law. And this is what we're trying to do. But what's the problem? That we need to do this under a special legislative procedure. So that's why we are doing this under this special legislative procedure and under this legal basis. It's not a policy decision. It's not a mistake on the part of the Commission. It's not a desire on the part of the Commission. It's the legal limitations that we have currently under the current treaties. Thank you.
Thank you very much. It was really very interesting, and it's not just politeness. It was very interesting. It doesn't happen every time, so thank you. Now, I really know sometimes, you know, people are different people are coming here. Yes, it was very interesting, really. So, and now floor goes to Ms. Alina Trifanidou to wrap up this discussion. But please, let's try to make it in 3 minutes.
Okay, 3 minutes.
Yes,
great.
thanks.
So, thank you. Well, then I'm very lucky that Maria Villar Badia has said so much because she answered most of the questions, but I'm going to say a few points as well. With regard to the legal basis, I would like to also say that this instrument is not just a free movement instrument as well. It goes much further because, after all, it covers every single child, irrespective of the nationality of the child and irrespective of the nationality of the parents. So we may have a family comprised exclusively of third country nationals that they simply want to have cross-border recognition of the parenthood. That doesn't involve free movement rights, the exercise of free movement rights, but it does involve cross-border recognition, so it's important to bear that in mind. Now, regarding the very important issue of competence, subsidiarity, etc., etc. First of all, the instrument doesn't say anything about marriage, whether opposite sex or same sex, as it was mentioned in the questions. And actually, in its Article 3, it specifically says that the regulation shall not apply to the existence, validity or recognition of marriage. So it's clear that the instrument doesn't intend to impose anything on member states regarding same-sex marriage or anything like this. Also, more broadly, the instrument doesn't impose any requirements on member states with regard to what is a family, what must be considered a family, surrogacy or anything like this. So if, let's say, the instrument became legally binding tomorrow,
the member states would continue to be able to maintain their laws on surrogacy as they currently are. So it doesn't intend, this instrument doesn't intend to change the substantive family laws of the member states. What this instrument is about is simply about ensuring that if a child has, under the law, one or two parents in one member state, that child will continue to have those parents in every part of the EU. So it's not about introducing, let's say, parenthood by same-sex couples through the back door or anything like this. It's just to ensure continuity of the ties of the child with the child's parent or parents, which, after all, is a fundamental human rights issue. As I said in my presentation, this continuity in the familial ties between the child and the parents is already required under human rights law, under the European Convention on Human Rights, which is not an EU instrument. So this instrument wants to ensure, as a requirement of the rights of the child, exactly that the child will be able to maintain the ties with his or her parents everywhere in the EU. So it's just about that. There is no agenda behind all this. Okay, I think the 3 minutes have finished.
I'm afraid yes. But in the beginning you had 35 instead of 10, so no reasons to be angry with us. Thank you very much. It was very interesting and very passionate discussion. I wish us all good luck. And thus we move to item 7, which is petition